Good evening, ladies and gentlemen. Welcome to the Rates and Lanes podcast. I'm your host, Rico Muhammad, joined here by our resident legal expert, Mr. Hank Seaton. He's sitting in the chair for Chuck this week. Chuck took off this week to go handle a little bit of personal business, so we gave him a little reprieve, and so Hank was gracious enough to join us again and jump in the seat. And it's always a great time when we got Hank on because as we all know, Hank always comes with the wealth of knowledge. So, like I say, our resident legal expert. If you got questions pertaining to anything contract law, transportation law, any of that type of stuff, if you got a question, you can put it down in the chat. You can type it right down in the chat, or I'm going to post a link here in a little bit. If you want to come up and be live with us, we invite you to come on board. There's no such thing as a dumb question or a stupid question. It's only a conversation amongst friends. So we always welcome your interaction here on the Race and Lanes podcast. And with that being said, good evening, Hank.
Hello.
It's been just a little while since we had you on, but I'm glad that you took a little time to come back and hang with us again. How have you been since the last time we talked?
Oh, I don't know. I think life gets more hectic as the days go by. What can I tell you?
Well, we just dropped the link down in the chat, ladies and gentlemen. If you want to come on board and ask a question, we got the man of the hour, Mr. Hank Seaton, is going to be with us for the entire hour. So if you got a question, go ahead and put it in the chat or click on the link and you can come and join us via video. So Hank, it's last time we talked a little bit about the whole situation with the dispatch services and things of that nature. And I've been seeing on the Overdrive actually has a big article on their front page as well, and it seems to be a lot of fraud still taking place within the industry. A lot of people are being hoodwinked and bamboozled. I don't know if it's dispatch services or if people are just flat outright just stealing loads or however you want to do it. But the Overdrive had an article here that was talking about how costly it can be. That it'll cost you more than just money. Anything that you're hearing on as far as your circles that you travel in on the legal side, as far as how rampant of a problem is this?
My guess, Rico, is the FMCSA doesn't really understand what it's going to do with this. It got plenty of comment. It doesn't. It doesn't really have any felt need to clean up the problems of double brokerage and those things. That act was passed in 2012, and to my knowledge, the FMCSA has never prosecuted anybody for double brokerage fraud, although they have the statutory authority to do so. In fact, they told one guy who asked them, laid out a fraud for him and said, hey, will you use your police force to do something about it? They told him to go contact the postal inspectors. And, if you know anything about the postal inspectors, their mandate has been significantly cut back when the internet came in. And I don't think they'd even understand the issue. So I don't expect to see the agency provide any clarity anytime soon. I think that the problem of double brokerage and abuse and the size of the scams are just incredible. As I think I've mentioned before, we filed comments on behalf of a dozen or more people. And made the point that there's about 6 different ways, and I haven't, as I said, you can tell me how close I am to the Overdrive, but there are about 6 different ways that you end up getting messed up if you let a fraud in the middle. First of all, the frauds are going to look to people who quick pay to get money for loads when the day they're allegedly delivered. That way, they figure that it's going to be at least 45 days before the actual carrier that hauls the load starts coming looking for the shipper. And in that period of time, they can make their ill-gotten gains and escape. So that's the most typical fraud. And unfortunately, the fraud tends to run in packs. And uh, although people say, well, I've got MRIS or I've got something else, uh, if they've got it and it's worth anything, it hadn't really proven it because these people are able to uh, get away with huge sums of money, and then nobody seems to be able to prosecute the guilty. Just ends up being a convention between uh, uh, the hoodwinked shipper or broker on the one hand and the hoodwinked carrier on the other. And that's not a pleasant result. I mean, from my point of view, a convention of victims uh, to fight over the carcass doesn't make any sense. The real issue is how you're going to stop the predators. And most people say, well, gee, there's not just enough money in one or two loads if they spread the crime around for anybody to get bad enough to take off after. And it's a sad thing. The other issues, of course, is if you're a broker and somebody said that they were representing you or stole your identity, and they checked out your years of business, your references, your CSA scores, they would have credentialed a licensed, authorized, and insured carrier with very little upstream liability for negligent selection. If it really wasn't RICO, and it was somebody who went out and hired an 18-year-old to come pick it up and had no driving experience and three drunk records, guess what? When he hits a school bus, all of a sudden the broker and the upstream shipper are going to be hit for negligent selection because there's no chain of custody here.
So basically,
and that's
I'm sorry.
that's what is leading shippers more and more to tell the broker they want them to have umbrella negligent selection insurance so that they can get the shipper out of vetted carrier hits a school bus. And if you can get that kind of insurance, it just adds to the cost. So you meet yourself on the road there. Say nothing about a cargo claim. If somebody vets you and you got cargo insurance, but then it's a scam and the other guy doesn't, what's the broker going to do? Your insurance company is not going to pay a claim unless it was on your truck. They're not going to pay a claim for somebody who negligently took your identity.
So, in other words, our elected and government officials this is not a big enough of a problem for them to even step in and even try to track this thing down and prosecute anybody, hold anybody accountable.
Well, it's not a perceived problem to them, but I think what they are saying is, what don't you get, public? Our name is the Federal Motor Carrier Safety Administration. Safety is in our middle name. It's in our DNA. Our sole goal is to not rest until there are no highway deaths involving 18-wheelers. And we can't even get around to auditing more than 1,200 carriers a year. What makes you think we can go and have a police force to police the industry? And this is their answer. Look, the statute's got a self-help provision in it. Nothing keeps you, RICO, from going into federal court and saying, I want my attorney's fees. I know I got to go find the crook and find out where his bank account is. And I know I only get my attorney's fees if I can find the crook. I mean, you really can't very well. I couldn't advise you to take that on. you need to you need to know where he banks, and even though you probably got a canceled check on the crook, the bank's not going to give you any banking information unless you're the federal government. So traditionally, people get all bent and twisted about it, but unless you put together both ends, honest shippers and honest brokers, and say we're going to end this scam and we're going to follow the money, and
Wow.
somebody's going to get enough jail time and a big enough fine to uh, uh, you know
This
break
just seems
over.
like this almost seems like the perfect scam if you can pull it off, because there's, like I say, there's no one there to hold you accountable. I mean, there's no one that's really investigating as far as trying to track down the culprits that do all of this stuff. And so it sounds like, especially a small guy, you're pretty much on your own when it comes to dealing with this stuff, and you need to make sure that you are doing your proper checks and balances and vetting people. But hell, if they're taking people's credentials, or if they're kind of chameleon as a legitimate broker or whatever, then I'm not sure. I'm still not even sure how you can, if even if you following your checks and balances, how you can kind of protect yourself from it.
Well, and at some point I may get my act together enough to put this on in a pay for view, and you help me get uh, YouTube down right or whatever. Maybe we can charge it a little bit and give some people something that's valuable. But I'll give you a couple of suggestions to start.
All right.
No, number one suggestion: if you are going to transport a load, you need to instruct your driver that he is to look at the shipping document the broker gives him, or that he gets when he goes to pick up the load. If he goes in and says, "I'm here for pro number 1005 and I'm going to Oshkosh," and then somebody hands him a bill of lading and he puts it in his truck and pulls away from the dock, he should be violating every rule of commerce and good sense. First of all, there ought to be a chain of custody protocol for every carrier and every shipper and broker. And they really ought to be the same thing. The shipping document doesn't have to be a bill of lading. It only has to be a receipt. It's not issued by the receipt, not the contract, but the receipt is given as an exchange for possession of the goods. The receipt is supposed to, like a warehouse receipt, is supposed to prove who it is that's entitled to the bailment of the shipment in transit. Okay? So, if, for example, the feds want to stop somebody who's at a truck stop 10 miles from a tire plant and want to say, "Hey, Bubba, you got a load of tires, don't you?" And he says, "Yeah." And he wants to say, "Well, prove to me it's not stolen." Then the driver needs to be able to say, "Well, look at here. Here's the signed receipt, signed by the dockhand, saying that Crescent Carriers is in possession. This proves that I'm in lawful possession of the goods, and it's a good in transit." 65 to 70%, you may think it's greater, of the bills of lading that get issued as shipping documents don't have the name of the pickup carrier on it. Certain number of those probably have the broker's name as the carrier. Some of them have nobody's name.
Nobody.
Nobody. Well, now you tell me, does it make good sense if you're accepting responsibility for the safe delivery of the load, you want to be able to have recourse to the consignor. You want your insurance company to say, and it does say in all those insurance contracts that they'll pay if you're liable pursuant to a contract or a shipping receipt. If the law says you got to issue a receipt that shows who hauled it, where it was originating, where it was going, was it received in good order, that you have a complying document. So that protects you. It also certainly enhances your rights to say, look, it's really pretty clear. If I wasn't the one that was authorized to pick it up, Mr. Consinor, you should have told me. You weren't, if I wasn't the one that was going to get paid, you should have told me. Now, from the shipper point of view, or from the broker point of view,
Okay.
the broker doesn't want to get caught in the middle. The broker does not want to have the load double brokered, have somebody assert a lien against it, it not get delivered, and bounce off his reputation with the shipper. He certainly does not want crescent carriers to get hung, and you go out and hire some collection agency to go to his good shipper and make him look like a fool. Okay? So the broker has got every reason to want to ensure that if he hires you, you're the one that picks it up.
Timely, safe delivery.
Yeah, time and safe for delivery. Now, the problem is a lot of large brokers and a lot of particularly large carriers who have broker divisions and outsource freight aren't really very anxious to tell the shipper that, oh, you may be able to have some subcontractor for us that'll cut the rates. So, I mean, they may want to preserve the notion that they are the carrier and keep the subcontractor at arm's length from the shipper. So that's the reason that lots of times I think you see a shipper's name, a carrier's name on a bill of lading when you're actually dealing with their broker affiliate.
Right.
I think that a carrier who is brokering out some of his freight needs to make very clear on his load confirmation sheet that it's with Crescent Brokerage, not Crescent Carriers, and that the shipper is told to show Crescent Brokerage as the third party pay to without recourse, and that you're sending in Seaton Transport. Be sure that Seaton Transport docket number 2005 is the carrier you give it to. Now, I think that ultimately your documentation to your shipper or broker and to and from the broker to the carrier should reflect that. Should reflect that at the time the load confirmation is issued, there's a contract in place to haul the shipper's freight, that the intermediary is listed as the third party bill to, and that the consignor should be sure that the retained carrier listed picks up the load. And that the carrier is instructed that if he gets there and his name ain't on the load, or the consignor's got a problem with it, that's when you should politely tell the consignor, look, I don't know who you brokered this to, but I'm supposed to be here picking it up for Crescent Carriers. Is he the guy you're doing business with? I mean, don't get the road halfway down the load 3 days late to figure that out.
And that's kind of a crazy little situation. Like I say, you if you find yourself in that situation, it's can be kind of a pickle to get yourself out of, I'd imagine.
Yeah, it is. I mean, when I was trying to come up with an analogy, I thought about this. As I travel around, I got to go rent
Hmm.
cars. Okay. And the cars that I'm renting cost a whole lot less than a trailer or a load that's worth $50,000. They don't let me get out of the gate until they check the name on the contract against my credit card. So now, why is it that freight's so much different? Why is it that anybody can say, "Well, I'm here for the blue Mercedes," and they throw you the keys and say, "Have at it"? I mean, that's just not reasonable security.
So what?
And I'm just saying that a chain of custody uh, uh,
Right.
protocol in everybody's interest.
So like I said, this thing can be a real entanglement of webs that's crossing, and you got you as a motor carrier. Here you are. If it's not yourself, you got an employee with the equipment that's tied up with the load that you don't know whether or not you're gonna get paid on. So but as the motor carrier, you got the wages involved. You got the cost of operating the vehicle, all that stuff, the insurance and all that stuff, and you still not sure as to whether you should deliver the load, put the load into a like you say, a search your lien, and maybe put it into a warehouse. Um, that's something that maybe one of these days we might should go over a little bit too, Hank. I don't know. Well, maybe or maybe not. I don't know. I don't know if we ought to empower a whole bunch of people that don't really know how to pull it off properly to be call themselves a certain lien and putting loads into a bonded warehouse.
Yeah, uh, it's something that people of goodwill should resolve before everybody says, "Well, I'll just stonewall the settlement and run up the bill, and then when we litigate it, it'll somebody will win or somebody will lose over a whole lot more money than it takes to make this thing go
Does
away."
it the question about these type of situations? Does it seem to be more smaller brokerages that are having these issues, or are the big guys also getting caught up and entangled into this stuff?
The big guys are getting entangled.
Ah, so if you so
The big guys, the big guys are getting entangled. I mentioned the pleading that we filed in the dispatch service thing, and we use three examples, all involving at various stages big guys. Uh, One in which a double broker scheme burned 173 claimants that filed against the bond. And when you drill down to it, now brokers are getting sued uh, by the small carriers thinking they've got recourse. And I know a huge broker got caught up in the scam because they didn't qualify the carrier, and the carrier they hired wouldn't have passed a close scrutiny test. I mean, let's face it. If you this is another secret, not a secret, it shouldn't be. But if you are a shipper or a broker looking for a co-broker or looking for a carrier, particularly if you're looking for a carrier, uh, and he goes through MRIS and passes all of that, so he's safe. Don't you think you ought to look a little deeper and see what kind of business is this guy in and how many trucks does he have? Well, it's on the FMCSA website. He's got to fill out a
right.
150. All right. So that shows how many trucks he's got, and it shows how many miles he run, and you can see how many inspections he's had. Okay, and you can see where his home office is, and you can even see what type of goods he hauls. Okay, now I'm aware of a scam in which a large broker put well in excess of $500,000 on a carrier in California who the FMCSA website show had one truck. One truck, and they were giving him 20 loads a week.
What?
Yeah, yeah. I mean, there was apparently nobody once he was qualified to haul freight that was doing anything else other than telling a crook, "Thank you for that load.
They
Give me
didn't.
another."
So that didn't make anybody's antennas go
No,
up.
it didn't do a thing. And when we really drilled down to the guy whose theft he stole, okay, he was a one truck Charlie operating an intrastate only, but he was vetted as licensed, authorized, and insured, and passed the smell test. So what I'm telling people is, look, I'm a firm believer in the fact that uh, if the federal government tells you that a guy is licensed, authorized, and insured, they've made the decision that he's fit to use if he's operating his own equipment, and you shouldn't have to second guess that for purposes of vicarious liability. But you damn well need to dig a whole lot further if you're going to smoke out a fraud. Okay? And I'm just saying that as part of the rules of the road, if you are a broker checking out a carrier, you need to drill down and see what his capacity is. And you damn well need to not hang up the phone until you do a couple of other things. Number one, you need to be sure that the phone number and the email you get from the guy is the phone number that will ring to where the FMCSA says the carrier is located. You probably need to be sure that all of your correspondence runs through the carrier's address so he can't come up after the fact and say, well, it's wrong. And you need to look very carefully at the domain on the emails you're getting from them. I was involved in one tonight in which, when the client realized he was being scammed, it was because the email address over which the documents were coming was like Rico at Crescent Carrier Inc. And you were Crescent Carrier us with
Right.
an S. Only difference in the
Right.
domain was one
Yep.
letter. And the crooks had managed, I don't know where they were probably in California, but they had managed to redirect the ultimate phone call so that the phone call came out of Iowa, wherever it is that the actual victim of identity theft was located. So those things were very, very closely related.
Right.
I had one. I had one this week in which, when we started drilling down to the fraud, uh, in the second level of it, up popped one of the most respected brokerages in the industry. And when they sent me the invoices and bills of lading qualifying it, it had this broker's distinctive logo on it, and everything was tracking to the town. I told you the town. I tell you who the broker was. Well, so I called up the broker, and I said, "Look, you need to help me because I got a client sitting out here hadn't been paid, and one rung above them, they thought they were doing business with you." And the carrier relations person said, "Send me all you got." I said, "Well, look, you're going to look at the documents, that see enough of them to realize it sure looks like your documents. And, at that point, she said, well, I can't promise you that some former employee or agent hadn't done this. I can just tell you that this isn't the first time, and we checked it, and we had nothing to do with it.
Wow. Wow.
So it's not just, I mean, you look at it this way: these guys are predators, and it's just like the apex predators like to cut the little lambs out of the flock. But that doesn't mean that you know the bigger they come, the harder they fall.
So this speaks to another thing as far as what you were just saying. Um, Making sure that we're doing a proper inspection when you're going to go pick the load up. Make sure you're doing a proper inspection of all the paperwork or the chain of custody, whether it be a bill of lading, warehouse receipt, whatever it may be. But make sure that you're doing that you are investigating that. And if you're in a situation to where there is no broker's name or anything like that on that documentation, how should you proceed then, Hank? You got any advice on that?
Well, the couple of things give away. If you go pick it up and there's no third party bill to, I would probably instruct the driver to say, "Hey, look, I was instructed by dispatch to pick up this docket number on behalf of Crescent Carriers. Are they your agent? They the ones I'm supposed to bill." Okay. And if the consignor can't tell you that, and the dockhand can't look it up, but they sign Section 7, which says don't deliver this load without getting
Right.
paid, then I think you're perfectly within your rights to certainly, if the load is under tenor, call up the broker and say, "Look, man, I couldn't get any verification from the consignor that you were the third party bill to. In fact, he signed Section 7, and that means that if I deliver this load without getting paid, I may be SOL."
And see that my
So
mind,
here's my wire number. Here's my wire number.
my mind keeps coming up with
We're gonna have to work this out.
different stuff, Hank. When we talking about this stuff, I start thinking about, well, what if you got a crookster or whatever on the line, and they've been in the industry for a little while, and they might be a little hip, and they might be like, well, it's a blind shipment, and there's a scenario to where they're telling you that it's
Well, yeah, but look at it this way: when it's a blind shipment, what they're concerned about is the customer knowing where it originated. Now, whatever kind of flappy ass shipping document you're going to get is going to show where it originated and where it went. If they're going to cut a blind shipment, they're going to tell you this is a blind shipment. You pick it up and make out a separate bill of lading that shows that it originated somewhere else. I mean, a blind shipment, the purpose of that is to keep the uh, uh, the buyer of the commodity to know where
right.
the beneficial owner of the goods was located. I mean, you see a blind shipment probably in a produce shipment where they don't want the grocery store to know where the orchard was or something. But in the situation we're talking about, it's not typically that the document doesn't show the
Okay.
origin of the shipment. It doesn't show the destination. It just don't show the carrier or who's ultimately responsible for paying the freight charges.
Now,
And the question is, at some point, both the consignor and the legitimate carrier deserve to know that the right person is picking up the goods and be able to trace the money.
So, and all right, so let's play it out a little bit further. If you find yourself in under a situation like this, you got possession. Possession 9/10 of the law. You got possession of the load, and you find out you dealing with some shady characters. Should you the first phone call you should make, should that be to who should that be to? Should that be to your insurance company? Should it be to an attorney? What are the next steps that you should do if you find yourself in this type of situation?
Well, I don't believe you ought to just go slap a lien on a loan, but I certainly think that if there's fraud in the system, that you do have a possessory lien unless you waived it. Now, a lot of contracts you sign, you have to
Right.
waive it, uh, and you have to waive any interest and attorney's fees, and you have to agree to bill only a crook. Now, signing those kinds of provisions, I think you need to cross out. But otherwise, I think it's pretty established that if you pick up a shipment uh, and uh, there is an inherent transaction going on, you are agreeing to provide a service in return for payment of some charges, and that you're entitled to know who's primarily responsible for shipment, for paying it, and anybody that leaves that ambiguous, intentionally ambiguous on a bill of lading, is either dumb or somehow complicit in it. I think we all know that it's become such a common practice not to put the carrier's name on it that you can't say it's gross negligence to do it. It's just simply done all
Right.
the time. But in terms of a protocol to prevent fraud and straighten it out, I think that's what needs to be done. You may remember I wrote a book uh, back about the turn of the century. It's 20 years old. It was called Protecting Motor Carrier
Right.
Interests
That's
and
the one I
Contracts.
very first had that.
Yeah, well, in there, I used the I guess a litogram of
Right.
cows, which stood for uh, uh, service terms and conditions and website and stamp. So what it was every carrier ought to publish his own service terms and conditions, preserving the rights and remedies that law allows. Okay, then he should publish those on his website, not be bashful about it, so that the shipper is directed to it. And then, if he gets in a squirrely bill of lading that for some reason you can't tell who provided the service, when they send out the invoice, they need to have what I call the POD stamp. And that said, this proof of delivery is service provided by X. Okay. Now, I had a large carrier who followed that as a collection procedure. And, you know, it was hard as hell to get that off of the bill of lading when it went back up the supply chain. And I can't help but think that didn't certainly aid in their uh, collection of freight charges, because it's kind of hard for a
Right.
shipper to admit, yeah, we paid that damn thing, but the bill of lading clearly showed that Crescent Carriers provided the service.
Right. Right.
So I'm saying that's another little trick that it's not really a trick, but it's another thing of best
Right.
procedures. If you are required to provide a proof of delivery with an invoice, then at some point you ought to a payor of the charges should be able to see from the document that you provided the service. Let me give you an example of that. I was talking to a major uh, company that pays insurance or pays out on brokers' bonds. And they said that when they got claims by carriers, that listen, I'm not on the bill of lading, but I deserve to be paid because I handled that load. They would turn around and say, "What have you got to prove?" Okay, how can you prove you handled the load? Your name's not on the bill of lading. Well, if you said, "Here's a certified copy of the bill of lading," it said evidence of service provided by present carriers, I think they'd probably pay it. Otherwise, they said that they were drilling down to telling a claimant, look, you got an ELD, send us the ELD records to show that you made the pickup. Now, that's, I mean, that can be done. But, it seems to be a whole hell of a lot of work to actually establish that you were the carrier who made the pickup and the one that made delivery, when all the heck you got to do is get your name on the bill of lading at time of pickup.
So it's a worthwhile investment to invest 20 bucks or whatever and have your customized stamp made up at the Office Depot or Staples or something like that, and get your ink pad and just keep it and make sure that you issue one for every truck that you got that's out there making pickups, and require it as a standard standard operating procedures.
Yeah, I think you're right. And in fact, you've just given me a good idea. Uh, roadway, following best practices in the old days, would have their driver jump out of the truck. And when he went to make the pickup, it wasn't so much that they were afraid that the people wouldn't see the orange yellow trucks coming in, but they put a little stamp, nick it, and put it in the corner, and it said service provided by Yellow Freightways subject to tariff 100. So what they did was they incorporated their service terms and conditions by reference onto the bill of lading with a stamp. I like your idea about bills of lading are still on paper. Just hammer that stamp down. I guess you'd have to ask yourself if if you wanted to be a little confrontational with a dockhand who has probably not even let you on the dock, and he says, "Here, sign this." You said, "Just wait a minute, wait a minute." And he went and stamped it and gave it to him. What would he say then?
I'll tell you.
What would he say then? Unload it? And what did he say? Well, I can't take this with your name. You say, well, I was sitting here to pick it up.
I've had that scenario happen to me before. I've had that happen to me, and I ended up having to get them to unload the truck. They didn't want my name on the bill of lading. They said, no, this is brokered through such and such, and that's who's on the bill of lading. We don't need your bit. And I said, well, it can't go on my trailer unless I'm on the.
Well, I mean, the question is, if it's legitimately brokered and it's brokered to somebody that you expect to get the money from, you say, hey, look, man, I got this load from Apex. I trust them. If they're the one that you hired, you just put over here third party pay Apex, and you ain't going to have any problem. I trust them. I just ultimately have to look to you to give you the chain of custody you need.
Okay.
Good Lord, man, God forbid, I'm in a wreck and you need to be notified. It doesn't get there. You're going to want to know to be looking for Crescent Carriers.
Right.
Who do you think? Who do you think's picking it up? But I mean, where your rub is going to come is with large carriers who have broker affiliates, and they want to preserve, or their customer wants to preserve really the kind of fiction that the primary carrier, even after MAP 21, is solely liable for the delivery of the load. And that tracks back to, I'm sure you remember the days of interlining when, people didn't have the authority to get into Hohenwald, Tennessee. So
Yeah,
the bill of
good old interline.
said
Matter of fact, hey,
Origin
your
Chicago,
office did a
destination Hohenwald. Yeah, it was cut. It was cut on a a through bill of lading. So the connecting carrier's name never showed up.
yeah, because the interline. I tell you what, you guys had actually drew up an interline contract for me. Back when I first was getting started in this thing, I had a couple of carriers that I had that I was doing. I had some freight that I was giving out to. So that was the way. That was the old school way as a motor carrier, where you could broker freight without having a broker's license as a motor carrier.
Yeah, I mean, it's still on the books. What it says is that you don't have to have a broker's license if you, as a carrier, accept responsibility for the through delivery and handle the shipment for a portion of
Right,
the way. Now, what a portion of the way means,
right,
nobody knows. But I think it's really very clear that if I don't mean to pick on anybody, let's say Roadway. If Roadway wanted to go in and pick up uh, a truckload shipment and was out of balance, and at its terminal wanted to give it to you to drag to California, then they wouldn't have to do it under their broker's
right.
license. You would have picked it up at Yella's dock, and you would have billed Yella for your prorate split. There wouldn't be no broker's bond. There wouldn't be any
Right.
confusion about it.
Yeah, that's exactly right. I had a couple of trailers. I had a cotton manufacturer. I get wouldn't say a cotton manufacturer. I guess we'll call them. They made they made stuff for beds. The inner portion of beds.
Yeah.
And so had a decent little contract with them. Had a couple of trailers. We'd go over there and pick drop the trailers and go back and pick them up and bring them back to the yard. And we had a couple of other contractors that was working underneath us, and we would let them take them out and deliver them. And they would bill us, and we made a decent little spread doing that way. But I was under the impression that they took that away from us under MAP 21.
No, it's I can prove it. Brokers became so ascendant that the convenience interlining kind of went by the way. Previously, it was required because nobody had authority to legally deliver freight to Hohenwald except Hohenwald Freight Lines. So that's why there was so much interlining. But now there still is the interlining. Let me give you an example. One of the groups I work with is the Air and Expedited Motor Carriers Association, and a lot of that LTL freight will come in by air or through a major airport, and it will get sorted and segregated and put on a truck to go to another airport. So someone like uh, American Line Haul or somebody like that will fill in that middle gap. So at that point, you got uh, a line haul carrier that's doing the pool, and then you got somebody who's doing the pedal delivery on down the street, and it's broken up. So it's one continuous movement, but it may have three components. And the line haul carrier may hire somebody to make an interstate delivery. Well, that can be done on a through bill as an interline. And what they have is what we designed for you, which is a
Right.
concurrence. And the concurrence is just a very simple document that says that each party will accept responsibility for cargo loss or damage in transit. That under the Carmack Amendment, either party can be sued, but the ultimate party responsible is the one in possession of the goods at the time of the loss. And then all it really needs to say is that the money will be received in trust, and there is a, a interline trust theory, and will be paid to you upon receipt. So it's still around. It's just that it's in such a niche that people don't really understand its broader application.
Okay, I might have to go dig that one back up. Hank, we might have to have a might have to dig that.
Well, in a way, that is probably, with all that's happening with the owner operator, if a lot of you guys have to get their own authority, that may very well be the easiest way to do it. Or a big carrier who's got a trailer pool to outsource his excess capacity to smaller carriers, but him go over to the freight dock and pick up the shipment and then interline the trailer at his home base. So that, for instance, rather than sending you to Hohenwald to wait in a line to pick up an interline trailer, he'd have somebody shuttle down to Hohenwald, bring it back to Nashville, and you come up and pick up the loaded trailer and leave yours in the lot till you get
Right.
back. That makes a lot of sense. At that point, though, you would have you'd be bumping the dock of the guy you were extending credit to, and you'd be pulling his trailer. So a lot of this freight ferry kind of situation about somebody out of area code 909 holding your freight charges wouldn't be happening.
I'm looking at the time, Hank, and we coming up close to that time. We never seem to always have enough time when we get you on. But before we do get out of here, is there anything that we might need to be aware of, or something that needs our attention before we decide to wrap this thing up, but that we hadn't touched on yet? Anything coming out of DC or anything? I know we talked a little bit before the show. A lot of stuff's kind of still hung up because we got the election coming up. But is there any?
Yeah, there are a lot of scary things that is going to affect small carriers pricing. Uh, if we turn on our political axis as a result of the next election, expect there to be less opportunity for entrepreneurship, more government intervention, and some best way I can say it is unintended consequences. I'll give you a quick scenario to think about. With all of the attention being paid on electronic vehicles or on us getting away from renewable fuel, that tractor is going to weigh a whole
Right.
lot more. And if you are transporting batteries or other supplies that are made out of those things, they're going to weigh out long before they cube out. So, for example, I do work for auto haulers. They predict that once we go clean and green, their auto haulers will weigh out unless they get a weight exemption at 8 units rather than 10. So the productivity dump will be 20%. That means you're going to have to haul 20% more loads to get the same delivery capacity. Now, nobody in the government at this point is thinking about those replications, which would say that, if you don't want to take another productivity dump and have to try to find more drivers, somebody needs to make the push that we need to increase the weight as the national requirement up to 100,000 pounds. Now, for port freight, North Carolina, for example, you can pay $100 and you can go 100,000 pounds hauling somebody's import freight from China. But you can't haul 10 domestically made cars unless we get some relief. So, the unintended consequences of clean and green America is actually to be more foolish, require more labor, be less productive. And I think we got a whole range of things in which the implications are not very well thought out. I've looked at an actuary study that is really, really pretty good in terms of the estimated number of qualified truckers, probably the best in the industry, that want to be independent contractors and just see no future for it, particularly when they can't get the insurance or afford it. So, they say, look, we're just going to be making a bigger hash out of transportation to do away with the independent contractor model than we are to encourage it. And I see a lot of that coming out, particularly if we don't have some kind of balance in the Congress or somehow. Of course, in this election, the only chance to not have two really rough years politically is to keep the House and the Senate. If we could lose both of them, I say we, if the country loses both of those, I think that you could see a lot of deja vu all over again in terms of labor management conflicts, in terms of escalating costs that is going to only further interrupt the supply chain. That's just speculating. I don't know. Do you kind of agree with that?
You can't really tell. Can't really tell.
Well, I can tell you about some things that are in the pipeline that aren't going to be considered until after November 5th. And they're just kind of lining up at agencies. There's one called an administratively final rule on the co-employee status, and that basically says that if you're a fleet operator, the motor carrier that you're leased to is going to be considered to be a co-employer for all labor laws and standards. That won't be fun.
Whoa.
So you can't, at that point, you couldn't even opt out as an
Right.
independent bargaining group. So, all of those things, one man's public public welfare initiative is another man's loss of opportunity. And how that plays out, unfortunately it's a political issue. There doesn't seem to be any compromise.
Yeah, unfortunately. Well, Hank, I'm looking at the time. I want to let everyone know, like, share, subscribe, hit the bell for notifications for the future shows. If you want to get a hold of Hank, right below, I got his website posted right there in the comments. You can click on the link that take you directly over to his website where you can find this book. Mine's a little battered. Mine's a little battered and bruised.
Too tattered to even show up.
I'm gonna get it a little closer here. Rules of the road. You want to get this book. There's a wealth of information, whether you are a owner operator, a company driver, anything like that. I think you should have this book. I affectionately call this the Bible of the transportation industry, because there's so much information in here that you need to know, because you don't know what you don't know. And this will help kind of demystify a lot of things, will give you a ton of insight to everything from the type of brokers that are out there, to the type of motor carriers, to all the different things that you need to be mindful of in contracts. The deadly dozen, as Hank likes to call them, but there's more than that in there as well. But that's just kind of a brief overview. But if you go to his website, you can order this book. There's also a ton of information on his website, other links, articles, and webinars that he has posted up on the website. I encourage you to go over there and check them out. And by all means, if you need any kind of services, patronize those that are taking out the time to come on board and share information with you. I highly recommend that if you need anything done, contracts, anything like that done, very reasonable cost to have it done, and you dealing with one of the best in the industry. I wholeheartedly support, and I'll say that to the end of time. Hank is the man when it comes to those type of situations. He's always looking out for us little guys. So, help those, get in with those that are helping us in this industry, trying to keep us aware of the things and keep our butts out of a sling. So with that being said, Hank, I don't know if there's anything that you want to add to that, but Hank didn't pay me to say any of that stuff. That's just off of the strength of the relationship that we've built over the years, and just the different things that by him taking time out, coming on the show.
I appreciate your endorsement. It's meaningful to me. Okay, folks, this has been fun as usual. I hope next time I come back we have a bunch of
I
questions.
hope so, Hank. We got to try to encourage the people to come on board and ask some off the wall questions, because sometimes I think that mine may be a little bit too sanitized, and I try to tell people, it's a lot of people always come up to me and say, man, I want to come on, but I don't want to sound stupid. There's no such thing. We're just having a conversation. So thanks again, Hank.
Okay, tell us to keep it between the
Yes,
mayonnaise
sir.
and
Yes,
mustard.
sir. So tell a friend to tell a friend about the podcast. Until next time, ladies and gentlemen, stay safe out there, stay healthy, keep it in between the mustard and the mayonnaise. God bless you and good night. We'll talk at you same time, same place next week, God willing. God bless you and good night.
Night, guys.